I think there's a story here that's kind of gone under the radar, and it shouldn't have because it involves a significant amount of money. It turns out a judge has ordered the province of Quebec to pay damages of $164 million for willfully violating a person's right to appear before a judge within 24 hours of being arrested and detained. So, as I said, it's a lot of money and could mean a lot of money. When I say a lot, in the neighborhood, I think of $7,000 to people who fall into this category. Robert Kugler is a lawyer. He's at Kugler Candleston, the law firm that launched this, representing the plaintiffs here. Mr. Kugler, thanks for the time this afternoon. Can we do a little bit of backtracking here? How did this all come about? When did this start?
The case was taken in 2018 and covers a period from June of 2015 to March of 2020. And during that period of time, as you mentioned, the Quebec government had a system in place that did not allow individuals arrested and detained to appear before a justice of the peace within 24 hours, which is the absolute maximum delay permitted by the criminal code, not just in Quebec, but throughout Canada. And that 24-hour rule is considered to be the cornerstone of criminal procedure in the country, and it safeguards the fundamental rights of the right to be free and the presumption of innocence. When a police officer arrests an individual and feels in good faith that it is too dangerous, let's say, to release that individual, to allow that individual to go free, that is fine. But a police officer does not get to make that determination. It's up to a judge. And that is why the criminal code requires that the police officer bring that individual to a judge as soon as possible and at its maximum delay within 24 hours. And what was fascinating about the trial, and I use fascinating in a bit of a strange way, the government clearly knew of this rule and clearly knew that by not permitting appearances on Sundays or on statutory holidays, individuals' fundamental rights would be violated. But they chose not to allow appearances for budgetary reasons. So they preferred their budget over the charter rights of thousands and thousands of individuals, and that's why the class action was maintained last week, and the government was ordered to pay $7,000 per incident of the violation of the 24-hour rule. The reason why the judgment is for such a staggering amount is approximately 24,000 individuals saw their constitutional rights violated during that 5-year period.
By the way, these 20, are we talking about people just in Montreal, or is this across the province of Quebec?
This is across the province of Quebec.
So 24,000 people since the launch of this class action suit who were not granted a chance to be in front of a judge within 24 hours would all be eligible here to receive $7,000.
Correct.
And they have to, this is the old story, in a class action suit, you don't have to opt in, you just have to opt out. Is that still the case here?
That's correct. And nobody opted out,
sure.
Nor should anyone have opted out. This was a case taken by one courageous man who unfortunately was arrested, and it was right before a statutory holiday. He spent 38 hours in a holding cell in a police station, and it's serious to be in a holding cell in a police station. There is no service for these individuals. The lights are on at all times. You can't sleep. You don't get proper meals. You have no access to a shower. You can't speak to anyone. There's no television. There's nothing to read. There's nothing at all to do. And that is why the criminal code is so strict. You must bring that individual to court as quickly as possible.
So you noted the budgetary issue here. The government chose, obviously wrongly chose, to go ahead and do this because it made sense for them economically. This went to court. What was their argument with respect to why they did it?
Ironically, they pointed the finger at judges of the Court of Quebec and contended that it was the judges that were not willing to have these appearances take place on Sundays and statutory holidays. And that defense was rejected by the judge who presided this class action because that is not what the evidence demonstrated. The judges were willing to have these appearances, provided they were proper appearances. And it's never an excuse for the Minister of Justice to simply allow thousands of individuals to see their constitutional rights violated and to simply say, oh, I'm having an administrative dispute with someone or someone else. You must do something. These are charter rights that need to be protected at all times, and they are protected at all times throughout the country, including now in Quebec. And that was one of the interesting things that the judge decided in this class action. It was as a result of the filing of this class action that the Quebec government finally mobilized and began respecting the law and allowing appearances on Sundays and statutory holidays. And we're quite proud of that because the purpose of the class action regime is, one of the major purposes, is to bring an end to wrongful conduct. And that's exactly what happened. There is now a system in place that respects the law. And the other major social purpose of class actions is to give access to justice to those who otherwise have no practical access. And here we are speaking of 24,000 individuals, the majority of whom are vulnerable, have no possible way of going to court to advocate for themselves. And this class action will get them a substantial amount of compensation that they deserve.
Mr. Kugler, did police offer an explanation here at all?
The police were not called as witnesses at all. The police couldn't bring people to court for an appearance because the courts were closed.
So the wrongdoing does not involve them here. It involves the system, as you're outlining. The fact that there were no courts, there were no judges. By the way, if I have this right from when we started, this is now 10 years between 2015 and now when you finally got a ruling. Is that right?
Yeah, the case was taken in 2018, and it goes back 3 years earlier. That's the rule of prescription. So it began in 2018, and in a class action, the first major step is to get authorized to proceed as a class action. So that took a couple of years. And then, yes, it took a few years to get to trial, and the trial judge was seized with a trial of a month in January and February, and quite quickly rendered his judgment, which is 155 pages long. It is meticulous and thorough already in May. So that is quite quick. The other thing that happened in the interim was it wasn't only the Quebec government that the class action named as a defendant. There was also the class action against the municipalities of Montreal and Quebec City. As you know, they have municipal courts. The same rule of 24 hours applies to offenses that proceed before the municipal courts, and they too did not allow appearances on Sundays and statutory holidays. However, those two municipalities, with the writing on the wall, they settled the claims against them a couple of years ago. Those settlements were approved by the court. The Quebec government, which is responsible for the courthouses throughout the province, did not settle, chose to go to trial, chose to contest the class action, and lost.
Now, if I'm correct, with respect to the government's position, they still can appeal, can they not?
Right. So anytime there is a judgment on the merits, a defendant that loses has the ability to appeal, and they have 30 days to make that decision. What is interesting is when a lawsuit claims an amount of money, the amount that is claimed, if you win, earns interest, and the interest rate is set by government regulation. So you mentioned correctly that the judgment condemns the Quebec government to pay $164 million. But interest has been running on that amount since 2018. As of today, with the interest, the government owes closer to $245 million. And if the Quebec government appeals, and if the appeal takes 2 years or 3 years, and they lose, the government will owe an additional $45 million. So they need to make their decision very carefully before adding to what they owe by the tune of $45 million.
That's a staggering amount of money. And you said they have 30 days to decide?
Yes.
So we'll know soon enough. All right, Mr. Kugler, I want to thank you so much for your time. Very much appreciate it.
My pleasure.
All right, that's what's going on. By the way, those 24,000 people who will be affected by this decision, right now as it stands, if there is no appeal, stand to gain $7,000 each. Quite a story.